need to know about the long-term disability mediation process. Hi, I'm long-term disability attorney Nancy Cavey. When you file a long-term disability lawsuit in federal court, a federal judge will order you to attend what's called a mediation. A mediation is a crucial step in every long-term disability claim because it's an opportunity for you and the long-term disability insurance company to meet face-to-face to discuss your claim. In mediation, a neutral third party called a mediator will be in charge of this discussion. It's important that you remember that the mediator is a judge and can't make the parties do anything. However, the mediator's real job is to be a facilitator. It's important that you understand what's said at mediation is confidential under federal law. What happens in mediation stays in mediation. The mediation will begin with what's called a joint session. The mediator will explain the ground rules. Each side gets to give an opening statement explaining their view of the case. Of course, there'll be a disagreement about the strengths and merits of each side's case, or you wouldn't be in litigation. The mediator will then break up the parties and move them into separate rooms. The mediator's job is to convey offers back and forth between the parties and to test and probe the strengths of each party's position and move them until they come to a compromise. Remember, you can't be forced to compromise. Many times, a long-term disability carrier will deny a small period of benefits, say perhaps 6 to 8 months of benefits. They could, at mediation, agree to put you back on diary and bring you current in a lump sum. They certainly won't pay attorney's fees or interest. Even worse, after they put you back on diary, the whole disability claims process will start all over. And in fact, they may even want to secure what's called an independent medical evaluation or functional capacity evaluations so that they can deny your claim once again. Therefore, getting back on diary may not be a win. More often than not, a long-term disability case resolves in what's called a settlement. Obviously, the strengths and weaknesses of each case will influence the settlement, as well as the identity of the judge assigned to your case. There are many factors that go into evaluating the strengths and weaknesses of a long-term disability case, its value, and what's best for you, the long-term disability policyholder. If a settlement agreement is reached at mediation, the long-term disability policyholder, you, will be asked to sign a general release. In exchange for that release, you will get an agreed-upon amount of money. Well, what happens if a settlement isn't reached? The mediator will advise the federal judge that an impasse has been reached. That simply means that the parties were unable to reach an agreement and the case will continue in litigation. You haven't lost any rights to continue the litigation of your case by going to mediation. It's important that every long-term disability applicant understand the long-term disability mediation claims process so that you can move forward with your lives. If you have any questions about the mediation process, contact me, Tampa Bay long-term disability attorney Nancy Cavey. I can be reached at 727-894-3188 or at caveylaw.com.